Everyone, and welcome back to a very brief break. I hope you enjoyed the amazing musical performance. We have always believed at Truth and Transformation Conference and at the IARA Project that art is such a powerful fuel, both for the energy that we need, the soul and the spirit of this work, as well as to help us imagine a new world. Sometimes words fail us, but song and music can often fill those gaps. I also just want to say that we have a really special opportunity here to move from the space of the private sector, from philanthropy, from higher education to the public square, the public arena, the role of government in making good on the promise of a functioning, healthy, and equitable multiracial democracy. And I couldn't be more pleased to welcome to Truth and Transformation Attorney General of the Commonwealth of Massachusetts, Andrea Campbell. On January 18, 2023, Attorney General Campbell was sworn in as the 45th Attorney General of the state of Massachusetts, pledging to build economic prosperity and stability for all residents, to prioritize the mental health and well-being of children, to stop cycles of incarceration and violence, and to ensure that the people across the state of this state of Massachusetts have access to the AG's office, regardless of their zip code, language, or ability. Growing up as a Roxbury native right here in Boston and experiencing many of the failures of our public systems where her family is concerned, she has turned those life lessons into a blueprint for equity for all. She graduated from Boston Latin School and then worked her way through college with the help of grants and student loans, graduating from Princeton University and UCLA Law School. After earning her law degree, she worked as legal services attorney for the Ed Law Project, defending the rights of children and their families, particularly those with disabilities. Attorney General Campbell also practiced law at Proskauer LLP as an employment attorney and ultimately left to serve the public as general counsel at the Metropolitan Area Planning Commission, working across 101 cities and towns to address regional challenges like healthcare access, transportation, affordable housing, and climate change. Attorney General Campbell served as legal counsel to Governor Deval Patrick, working to improve our education and transportation systems and to move forward an agenda of equity across the state. She, in 2015, successfully ran for the Boston City Council, becoming the first woman to represent District 4 on the council. Her first piece of legislation was the Community Preservation Act, which still generates over $20 million annually for new affordable housing, historical preservation, and parks and open space. In 2018, she was unanimously elected City Council President, the first Black woman to hold that title. It is such indeed a great honor to welcome you. We met at last year's Martin Luther King breakfast hosted by St. Cyprian Church here in Boston, an annual tradition, 54 years going strong. You spoke at the event. I spoke at the event, and I think we've been wanting to be in community and in shared collaboration with this work. So just a real treat to have you, and the floor is yours.
Oh, thank you. And I'm going to call you Dr. Muhammad because I'm grateful to be here with you. As I said at that MLK breakfast, when I saw you were on the agenda to speak, I said, okay, let me change my no to a yes to show up, just being really candid.
Awesome.
Because I just value the work that you do through your writings, your books, and in the way in which you do. And I think even when you spoke at that breakfast, you didn't mince your words. And I thought, oh my goodness, Harvard, look out. And then, of course, your incredible team. I'd be remiss if I didn't extend gratitude to your team, right? None of us does this work by ourselves. Just know that the work that you all do informs not only what we're doing at the AGO in public service, but it is showing up locally and nationally. And so you should be applauded for the work that you're doing. And thank you for having me be a participant today. And of course, thank you to everyone who is showing up for this conversation on DEI, but also all of the effects of DEI right now that we're seeing and the backlash we're seeing, because it really is a timely conference, a timely conversation to say the least. So just delighted to be here. I'll share a few remarks and then happy to engage in Q&A from you or from the audience. And sadly, as I sit here and the attacks continue, whether it's across the country, but in our courts, our local elected bodies, our institutions, our communities, The attack on DEI, diversity, equity, and inclusion efforts are significant, and they're sadly not going away. And of course, there's plenty of misinformation out there surrounding it, and not necessarily a lot of accountability for those that are pushing out that misinformation, which is also equally unfortunate. And despite the backlash, and I would say potential setbacks to DEI, most recently because of the Supreme Court decision in Students for Fair Admission, I actually think that this is the time for us not to take our feet, and I would say both, but take our feet off the gas, but to do the opposite, right? To be really aggressive and to operate with a sense of urgency. And if anything, I think that decision should put fire under all of us to really delve into what else we could be doing, either lifting up what we're already doing or really thinking outside the box on what we could be doing to help our young people, to help folks who are operating in various industries, pushing and promoting what DEI means, what it means for an institution, what it means for individuals within an organization, and of course, what it means to all of us. And so I do think there is so much that we can be doing. And so our frame in the office and everywhere I go is one of positivity, not negativity, which I think is important. We need to carry joy in this work because it is hard work. And I think there's a lot of things actually in our control to advance racial justice, diversity, equity, inclusion, not only in the educational context, but in workplaces and various other institutions as well. We can support, of course, our students, including students of color and those from historically marginalized groups. We can continue to fight to break down barriers to education, to housing, to economic opportunity, ensuring everyone, not just in the Commonwealth, but everyone in this country has a brighter future. We can, for example, in the education context, invest in our K through 12 schools, which has been a topic of discussion for too long on how we can do better there. We can reevaluate our missions and our financial aid processes to be more inclusive. Frankly, conversations we had even before this most recent discussion, and maybe now is the time to finally get it right. And lastly, I think we have been stressing too, and I think this is important, how do we also encourage folks to revise some of their admissions policies to allow students to share about who they really are outside of just checking a box? What are their life experiences? What do they bring that can improve an institution, make it better, and make it more inclusive? We can still do all of that and so much more. And of course, we also recognize, and you get this, and of course, all the folks who are participating, that most of the backlash dealing with DEI in the misinformation out there negates history, either lies about it or asks us to do away with it. In my office, at no point at any time will we be a part of any conversations or movements that discounts the historical and accurate historical context of this country. And I'm not only going to do that as AG and someone who is educated, who graduated from Latin school, from Princeton, from UCLA, but also personally. I sit here as AG with loved ones who are still incarcerated, recognizing the inequities in that system. I'm also a Black woman who gave birth to 2 Black boys, recognizing the inequities in our healthcare system. And of course, in our housing system, our economic system, and so many other systems. I know the Constitution. I know when it worked for us and when it frankly didn't, and when it dehumanized us. And so I share that because I think it's also equally important, this is within our control, to think about how in our work do we find moments to lift up that history, both stories and data points that are significant to whatever we're trying to accomplish. Because that too was what people are trying to unravel and eradicate. And then just a few other points that I think I want to stress is, I love my job. And I love, of course, being the first woman of color to win statewide office here in Massachusetts. I think that too is a reminder, as proud as I am of that accomplishment, that we still have work to do and that these inequities we talk about are real. But what does it matter if you are the first, if you do nothing with it? And so we're going to operate with a sense of urgency and boldness to take on the work, denouncing, of course, our Republican AGs, who sent out a letter to try to make this recent Supreme Court decision applicable to the employment context, which it is not. We are going to work with our governor and lieutenant governor and education secretary and everyone else We just put out guidance on ways in which the schools can review their admissions policies to make sure they are past constitutional muster, but at the same time, give them the resources they would need to be successful. We're actively working as an office with my DEI chief, Angela, who will be here shortly, Angela Clark, on how we can put out our own guidance to help folks in this moment in time. So do expect that to come at some point. And we're also going to take on the big fights. We are enforcing our MBTA communities law, which is a housing law here in Massachusetts, where we sued a municipality that is not enforcing that. And I can't stress that enough. I don't remember the last time an AG has sued a municipality, but we see this as a housing conversation, not just relevant to Massachusetts, but also relevant in this country, because it does involve a historical context of exclusionary zoning. And also, I'll just end with this. As we take on an intentionality to use the tools of the office to close the racial wealth gap, and to really expand our economic portfolio of work, and to remind folks that we have a space there in addition to our criminal work, we have not forgotten those who are currently and formerly incarcerated. In the office, for the first time ever in the history of the office, and we've been around centuries, convened a group of those who are working to help those who are formerly incarcerated rebuild their wealth, have access to mental health services, the tools to become better entrepreneurs, and so much more. And that is a big part of our entrepreneurial, or I should say, our economic work. And so I lift that up to just give the audience a quick snapshot of all that we're attempting to do in partnership with you and those who are on, and anyone who wants to be a part of this work. We, of course, will include our contact information. But we are about it. We're not wasting any time because we have no time to waste. Delighted to answer your questions and those of the audience, but really happy to be here and to be a part of the solutions, and not just to dwell with the problems. Our ancestors would want us not to do that. And so I'm looking forward to this conversation. So thank you so much for having me.
Thank you so much, AG Campbell. So I want to ask you a question that really is about the national scene to get things started, because I think it's really important for the people who've joined us here today, who are all over the place, to take some nuggets of wisdom and ways in which your office is working that may not work in other places. So first, let me just tell the audience, in July of 2023, you joined several attorney generals in 20 states, from Michigan to Maine to Maryland and a couple of swing states, including Arizona and Nevada, to denounce 13 other AGs in red states who threatened action against Fortune 100 companies who practice diversity and inclusion. And in the letter, you, amongst the other AGs, wrote, "While we agree with our colleagues that companies that engage in racial discrimination should and will face serious legal consequences, we are focused on actual unlawful discrimination, not the baseless assertion that any attempts to address racial disparity are by their very nature unlawful." And your office actually released its own press release where your office stated this, quote, "The Supreme Court's decision to outlaw affirmative action has no effect on private companies' efforts to recruit a diverse applicant pool and ensure that workplaces are welcoming and supportive of people of all backgrounds. Companies are not required to ignore history nor let present inequities persist. The Massachusetts business community knows this well, and I applaud their efforts." So here we are now, nearly 18 months later. And I guess, just to be clear, has anything in the law changed with your interpretation and those of 19 other AGs?
No, it hasn't. And if anything, we have been looking to get that letter more attention and get it out there along with that press release. It got some coverage, but frankly, we wanted it to get a lot more because we see it as a tool that people can use as they're pushing for more DEI initiatives or to expand what they're already doing in their respective institutions to keep doing that. And we actually say in the employment context and also in the private sector, that Supreme Court decision has nothing to do whatsoever with the private sector or the employment context, and that people should be looking to expand their efforts. The last I checked, we need more DEI programming, more resources put into that work, more human capital put into that work. And frankly, companies in the private sector risk probably welcoming more lawsuits and complaints for discrimination and harassment if they don't have those policies. So we're continuing to get out there to encourage folks to do what's right, but also to do what's legally sound.
That's a great point to emphasize about the fact that if we were, and I don't know that any economists have done this so far, although this would be an opportunity, I think, either if it's happened to lift up that work, speaking to the audience, put it in the chat. And if it hasn't had, it's a great research question, which is to say, what has been the cost to doing business in the United States over the past several decades for class action discrimination lawsuits filed by various employees of organizations that have practiced or serialized forms of discrimination in the workplace. Because again, much of the critiques that have been mounted against DEI are baseless claims. And even, I mean, I would love to hear you talk, very briefly about the reinterpretation of the 14th Amendment. I mean, one of the things that the Supreme Court essentially argued in the case was that the 14th Amendment was an argument, a defense for color blindness, and not as the original intent of the 14th Amendment, which was to protect the formerly enslaved with civil rights that were being violated in the post-emancipation South. And so maybe just talk a little bit about that, because I know, for example, Section 1981 came up, which is part of the 1866 Civil Rights Act, which was an attempt to address the violence that the formerly enslaved. But it's now become kind of the chief legal tool in so-called reverse discrimination cases. So just share with us just quickly a little bit of the sausage making of the Supreme Court decision and why people really do have to understand what the law is doing and not doing in this moment.
That's right. A couple things. I expressed my disappointment, of course, with that particular decision, but also with the Supreme Court generally. If anyone is paying attention, even if you're not a lawyer and you're a lay person, you can see the politicization of the court. People, the highest justices, of course, of the land, beginning to take positions based on personal feelings and thoughts and ideas, not on precedent, not on the ways in which we learned in law school decisions should be made in a legal context, including, as you just described, this idea that we are colorblind, which is total nonsense. We all know that not to be true. And I don't think you have to be a person of color to recognize that. The Constitution itself, if you know the original version of it, right, we wouldn't even be sitting here because we were 3/5 of a human being. So in certain contexts, at moments it was appropriate. And then in other moments it was not. And so I think we're taking a step back to remind folks that this court, unfortunately, will probably continue to dish out decisions that are not based on legal precedent, that are not following the ways in which we should be analyzing our laws and cases, but instead are infusing their political positions throughout these decisions. And I think people, of course, are calling those out in the various dissents, and kudos to those justices that are. But it's another reason why people need to get civically engaged, right? Because that is one way we're going to change it. So we have been getting out there actually to stress, including in response to this DEI letter from Republicans, they are using intimidation tactics, right? Even their letter is not based on the Supreme Court decision. As flawed as that decision is, and it is, they are making it then mean and extrapolating the principles in it to make it mean that in other contexts, it applies. It is not. It is narrowly focused on higher ed and actually on certain institutions, including, of course, Harvard, not in the employment context, not in the K through 12 context. We had a lot of confusion there. And so we are responding to these intimidation tactics with just that, saying we're not afraid, and laying out as best we can in a very practical way how people can fight back in this moment in time, even as non-lawyers. And there are a whole bunch of tools available to them. And we hope our guidance that will come out soon will also be helpful.
I think that's so powerful. And I just want to keep emphasizing how strong your language is with regard to what the law says you can and cannot do. And this notion of self-censorship, where people essentially are censoring themselves from either speaking to these issues or continuing to do the work, is such a powerful deterrent in ways that are not actually a problem just yet. I had a question about constituents in other places. So it's a big country. And so if I'm listening to this conversation and whether or not I'm in one of those states that helped to sign the letter that you were part of in July 2023, or I'm in a red state, What
Mm-hmm.
should constituents be demanding of their AGs around the country in terms of being committed, for the office itself to be committed to equity
Mm-hmm.
goals? And I'm going to put one little coda on this question. Um, we saw news reports just yesterday that the Los Angeles Unified School District is being sued for having essentially a program to support better educational outcomes for Black and brown boys. And maybe it's actually just African Americans. Like, I'm not sure if it's both. But the point
Mm-hmm.
is, you've got a population that, from an equity lens, needs a greater support for success. And they're now being sued for it. My question is there also a role, aside from constituents knowing how to make demands on the AG's office in general for equity,
Mm-hmm.
is there also a role for AGs to join as in litigation on behalf of clients like the Los Angeles Unified School District or like the Fearless Fund that just settled the
Mm-hmm.
lawsuit? I mean, what role can AG offices play in actually stepping in the gap where where the resources to fight some of these lawsuits may be limited?
It's such a great question, and it's perfect because I've been reminding folks in this moment in time how important your AG is. The average person, sadly, including here in Massachusetts, they don't know who their AG is or what the office is capable of doing to assist and help them. And in this context of DEI in particular, and fighting for racial justice, which of course doesn't just affect people of color, that affects all of us. That lifts up all of us. That helps all of us. And this opportunity that we're seeing across the country is just that, an opportunity. And we welcome it, where sadly, mainly Democratic AGs are coming together to fight the fight and to push back against Republican AGs that are using rhetoric, misinformation, or intimidation tactics to have different outcomes that stand in the way of racial justice. And so this is a reminder, I think, to many to, one, figure out who your AG is. Reach out to their offices. Every AG has a website. Some are better than others, but they have contact information there where you can reach out as a constituent to ask questions. What are you doing in the context of DEI? And not just externally, pushing for employers, for example, to continue to promote DEI practices, or bar associations, the ABA and others, to do the same. What are offices even doing internally? Do they have a DEI chief at their AG office? Do they have an office, a team? How are they applying an equity lens to their work? Ask those questions. And on your latter point, that of course requires constituents to do their part, and there's a role for them to play, and also get out and vote if you don't like what you find. But on the latter point, we do have significant tools and ways in which we insert ourselves, not only in litigation efforts here in Massachusetts. We file amicus briefs, I feel like all the time, inserting ourselves, intervening formally or less formal in decision-making across the country, in circuits, in courts across the country. The Fearless Fund, we did not insert there, but of course we followed it. And they settled that case, which in many ways is still a victory. And the 11th Circuit is one circuit. The First Circuit, where we are, is very different. We don't have that same precedent. So we're telling folks, keep doing what the Fearless Fund was doing. Keep promoting programming, as we see in LA and other places, helping those who have been marginalized gain access to capital and resources to start a business, to grow their wealth. Keep doing that. And so this collective fight is critical, because one AG in one state really cannot advance racial justice if we're not doing it in partnership. And so we can continue to expand our tent of people and allies and accomplices in this work. It's really important in this moment in time.
I want to, maybe this will be my last question, but I teach students about the history of race and racism. Apparently, it's very controversial and it's bad for America, according to members of Congress. But we'll put that aside for a moment. And one of the things that is really clear when you look at, just ballparking hit 400 years of American history, is that over the last 50, 60 years, anti-discrimination law has essentially not been very aggressively enforced at multiple levels of society, particularly at local and state levels, and also at the federal level. So maybe talk a little bit about one of your equity goals. You have work around environmental justice, around racial wealth gap. issues and closing that gap, housing. Pick one and talk about the relationship of both the programs that you're initiating and also how you may be using state-based anti-discrimination law to help to actually make the law work for people.
That's a great question. And you're exactly right. Even when I was running as a candidate, we said, what good is it if you have laws, but if you don't have an AG or someone who's bold enough to enforce those laws, especially those laws that are designed to protect our people against discrimination and bias and other forms of hate, frankly. And I have to pick, I could pick a whole bunch, but I have to pick housing, because housing right now is not only important here in Massachusetts, it's actually important nationally. And I appreciate that it's continuing to get the attention it deserves. We don't need another report to say, or another poll, that affordability right now is the #1 issue that people are talking about in Massachusetts and in this country. It's too expensive to buy a home, childcare, healthcare, your prescriptions, groceries, you name it, everything is too expensive. So we said here in Massachusetts, well, what can we do about that? We have a lot of tools available to us. What can we do? And we said, we're going to take on housing because we want to be responsive to that affordability issue. But we also want to be able to work on closing this racial wealth gap. And we don't need another report to tell us, and you know this based on your work and extensive work in this space, housing is one significant tool, not only to grow a family and an individual's wealth as an asset to close that racial wealth gap, it also affects the environment, public health outcomes, educational outcomes. It affects everything. And so we have said, if we're going to focus on that, how do we use our tools? And we have several tools. One is our litigation tool to implement the laws of our state. The MBTA communities law, which says build dense and multifamily housing near the T as a public good, it is mandatory. It forces municipalities to do that, which is in stark contrast of our housing laws that were voluntary before, and we know didn't really work because people always found a way to get out of it because it's voluntary. So we just sued a municipality not too long ago, of course, to force them to come into compliance and to push back on even some of the narrative that, you know, it's going to change the fabric of our community, which of course makes me think of exclusionary zoning. So if we're going to enforce that, we said this aligns with the enforcement of our discrimination laws here in the state, but also our federal fair housing laws, which at moments have not been enforced with the urgency that they probably deserve. So the housing piece is critical. And I'll just name the other tools of the office that are just as significant as litigation, because we know litigation can take a very long time. We have our grant making tool. So when we win resources from settlements in our enforcement efforts, millions of dollars that we can redirect into our communities. And so we take that money and we put out grants, including to mediation programming, local aid programs to expand our reach of the office, to help folks navigate disputes. And they can be housing disputes where mediation and a mediator could be helpful. That's significant in helping, of course, with our grants. Policy and government, another tool. We pass and file legislation. We have a neighborhood renewal division that worked that state house to improve our receivership statute. So now we're going into communities, turning blighted property, vacant property that is usually in poor communities and of course communities of color, and turning it into home ownership opportunities for families because we push for a legislative fix. And that is, of course, just scratching the surface of the housing portfolio. And one issue that we're addressing with a sense of urgency that I don't think has really been addressed this boldly, to be candid, in the history of the office. And to make sure we're doing it right and that it's intersectional across the office, we even established this housing affordability unit, which we just got off the ground. We stole Esme from the Harvard Legal Aid Bureau, who is now in our office running that new housing unit, to make sure as we do all of this work, it's intersectional, it helps people, not just help them up here, but so that they can feel the tangible results and impact of our work. And that's what everyone should demand from their elected officials. Everyone should absolutely demand that from their AG. And so we'll continue to deliver, but that's just one example of one issue we're using all the tools, but also most importantly, enforcing our laws as a solution to help people.
Well, I just want to emphasize that you started this conversation, this keynote, with reminding us that we must fight with a sense of urgency. And I want to close by reminding our audience that in our first panel, we heard several strategies, one of which was that, of course, representation matters, but also government matters,
That's
that
right.
who we elect to do the work on behalf of our collective well-being, on behalf of the public good, actually matters. It matters a great deal. And to have you in this role not only bodes well for the movement that many of us feel like we were part of. Some of us were conscripted into it. Some of us have been trying to lead it. But the point being that you are modeling that we have too often and for too long been passive in the wake of these local and state elections,
Right.
where there is power and consequence to who is representing our collective interests. So thank you so much, Attorney General
Thank you.
Campbell, for your leadership, for your work. We will be rooting for you because rooting for you means all of us win. So thank you for joining us today.
Thank you. And thank you for having me. Appreciate you.